Thank you all so much for joining us. My name is Dustin Saldarriaga, and I'm a senior associate with Scott Legal PC. I'm being joined today by my colleague, Jiyae Hwang, who is also a senior associate. We're very fortunate to have Jiyae with us. She has extensive experience preparing National Interest Waiver petitions. So, would like to touch on a few things before we dive in. Background information, really. The first is that our firm is a business immigration law firm, but we do assist with all aspects of U.S. immigration, whether that's family-based immigration, temporary visas like student visas, tourist visas, whatever it is, we would be happy to help. So we hope you won't hesitate to reach out to us. One of the things that I think makes our firm stand out is that our founder, Ian Scott, actually started the firm on a business visa, specifically an E2 visa. And before that, he held numerous visas in the U.S., including a TN, an H-1B, an F-1 student visa. So his experience navigating the process really does inform the way that we work with our clients. After this presentation, you will be receiving an email from us with a link where you can schedule a consultation if you'd like to talk through the specific circumstances that apply to you and whether the National Interest Waiver or any other visa might be a good option for you. We will also share this PowerPoint presentation, and that email will have a link to our YouTube channel where we post our full-length webinars. This webinar is being recorded. It will be posted to our YouTube channel. And also on our YouTube channel are shorter videos on, again, a variety of immigration topics. If you have a question during the presentation, please do send it in through either the chat function or the Q&A function on Zoom. We will be monitoring those. We'll probably save questions for the end, but we do plan to get through all of the questions by the end of the presentation. So please do send those in. And without further ado, I will go ahead and pass it off to Jiyae.
All right, thank you so much, Dustin. And thanks everyone for joining us today. So let's start with an overview of what do we mean when we speak of NIWs? What is this particular green card pathway? So NIW overview. So the NIW is a green card option that can be available when the government concludes that you're coming to the United States to do something that is in the national interest. So the NIW is short for National Interest Waiver, and it is a subset of the EB2 employment-based green card category. And when we speak of green cards, immigrant petitions, this means that this is an application for permanent resident status. And if you obtain this green card, this gives someone the ability to live permanently in the United States, work for any employer, or even not at all at some point. And having a green card also opens up the pathway to U.S. citizenship. Now, the EB2 NIW is a popular choice among individuals who want to apply for a green card on their own. And this is called self-petitioning, which means you can apply for the green card as an individual without a US company sponsoring you. Normally, for the general EB2 employment-based petitions, you will need a U.S. company in normal cases to sponsor you for a green card. Now, there are only a couple of categories that allow self-petitioning, and the EB1A, extraordinary ability, green card is one of them, but the EB2 NIW is also one of them. And if you can qualify for the NIW, this can be a viable option for a wider variety of professionals, perhaps who don't, yet qualify for the high standards of the EB1A, but can nevertheless show that their work will make significant contributions to the industry or society or to the region in a broad way. So let's look at a little bit of the requirements now. We'll go into more detail on the next slides on the Matter of Dhanasar test. But basically, to show that your case qualifies for an NIW, you do need to meet three requirements that Matter of Dhanasar lays out. And in addition to meeting the three-prong Matter of Dhanasar test, you must also show that you meet the EB2 threshold, which is applicable to both, employer-sponsored and NIW petitions, which is that either you must hold an advanced degree, which is defined as a master's degree or above, or you can also qualify with the equivalent of an advanced degree if you have a bachelor's degree in your field and 5 or more years of full-time progressive work experience after you received your bachelor's degree in your field, which is related to your proposed endeavor. Or you can show that you have exceptional ability in the sciences, arts, or business. Which is defined as the ability that is significantly above what is ordinarily encountered in the field, and you must be able to show at least 3 out of the 7 criteria for exceptional ability. Now, keep in mind, though, that it is a much lower standard than extraordinary ability, so we will be talking a little bit more in detail about that as well. Now, as I mentioned, before, you do not need an employer to apply for a national interest waiver. You can self-petition as a foreign national. You provide a plan, a proposed endeavor of what you're coming to the United States to do, but it does not need to be tied to one particular employer. And we'll go into a little bit more detail about proposed endeavors as well. So the waiver here relates to the EB2 requirement to prove that the one employer cannot find a qualified U.S. worker, which is the ordinary labor certification process. Now, if your case qualifies for the NIW, you're exempt from this. So you do not need a U.S. employer to sponsor your case. You do not need, to go through the labor certification process where, because your particular case would meet the criteria for the national interest, and as such, you would qualify for the exemption. The last bullet point we want to talk about before going into more detail about the eligibility requirements is that applicants in any field can apply for a green card under the EB2 NIW category. It is not true that only STEM fields can apply. We've had successful applications from many fields, including fields like law, a field like graphic design, for example. Really, the importance is the impact of your work in your field. And it is not really dependent on what your field is. So even if it's a very attractive field to the United States, for example, even if you're an AI engineer, if all of what you're doing is just to provide AI engineering services to one particular employer, and if you can't prove that the work for that employer would benefit, any other entity beyond just the private interest of that particular employer or your immediate clients, then actually it will not be a strong NIW case. Because what the government looks at when they look at national importance and substantial merit is what is the impact of your work in the field, not necessarily what is the field that you'll be working in. So it is a very important distinction to make, and a lot of misconceptions may be circulating on the internet, but really, the truth of the matter is applicants in any field can apply. The important thing is what you will be doing in that field. All right, so now let's go into a little bit more detail and talk about the threshold requirements. The EB2 category, and this is applicable for either perm cases with employer sponsorship or NIW self-petition cases, there is a threshold requirement, and you can meet the threshold requirement by either showing that you have an advanced degree, a master's degree or higher, such as a PhD, even a JD or MD degree can qualify as an advanced degree because you would typically need a bachelor's degree to gain admission to those kinds of programs. Or if you can show that you have a bachelor's degree in your field, and plus, if you have 5 or more years of post-baccalaureate full-time progressive work experience in that particular field, you can also be considered the equivalent of an advanced degree holder. And now the important thing to note is when we speak of progressive work experience, we need to be able to prove that. And the way to prove that is to get very detailed employer confirmation letters from your previous employers that describe not only the length of how long you've been working in that particular position, but also how your job duties changed, increased in complexity, and your responsibilities have increased. And you've, have been handling more senior, responsibilities over the 5 years that you've been working. So you definitely want to make sure that you have the right level of detailed proof for that. Now, let's say you don't have a master's degree. Let's say you don't have a bachelor's degree, or maybe you don't have the requisite 5 years of progressive work experience. Then the other pathway you can potentially use is to show that you have exceptional ability in the sciences, arts, or business. And The way to show that is providing at least three out of the seven enumerated criteria below. For example, official academic record for any type of degree, not necessarily a bachelor's or a master's. You can use that towards, proving exceptional ability. If you have, a license to practice your profession, if you have 10 years of full-time work experience, if you can show that you've received recognition for your achievements in the field by your peers, government entities, professional organizations, and other types of evidence can be used to show generally that you are someone who is working at a level that is significantly above what is ordinarily encountered in the field. And if you can prove that, if you can persuade the government of that quality, then you may be able to meet the EB2 threshold, even if you don't have a master's degree and even if you don't have a bachelor's degree or the required work experience. Now we'll move on to the next slide. Now, it is important to note that meeting the EB2 threshold is not the end of qualifying for the EB2 NIW because the NIW part of the case needs to be proven. And this is very important because if you cannot show the matter of Dhanasar factors and show that your case qualifies for the NIW, then what the government basically is going to say is you need to get a US company to sponsor you with a job offer and go through the ordinary labor certification. So the main challenge in NIW petitions is to convince the government why you need that exemption, why your case merits an exemption from that ordinary labor certification requirement. So let's go into more detail on the matter of Dhanasar test. The first prong for the matter of Dhanasar test is to show that the applicant's proposed endeavor has substantial merit and national importance. And keep in mind that there are three prongs in the matter of Dhanasar test, and all three prongs need to be met in order to, qualify the case for an NIW. Now, so step one, one of the most important strategic points in the NIW process is to clearly define the endeavor. And when we speak of a proposed endeavor, you must present a specific project or goal that goes beyond simply working in an occupation. So, for example, if you're an engineer, if the proposed endeavor is just one line of text saying, I'm going to be working as an AI engineer for Google, if that's all that you're proposing, then unfortunately, the government will not accept that that is a proposed endeavor. Instead, the government wants something much more specific and concrete. What are you doing in that occupation? So, in addition to working as an AI engineer, what are you doing in this field? Are you improving, for example, the technology that many companies can use on training AI models, such that in a way that makes it more efficient or requires less data or makes it more sustainable? In some way, are you advancing the field? Are you, uh, you know, improving best practices in a way in that particular niche where you're doing your research and development? Like those are the kinds of details that the government is looking for when you are proposing your endeavor. Now, when we speak of the impact of the endeavor, what the government is looking for is, does the impact of this endeavor extend beyond just benefiting the private interest of one company or the private interest of the direct clients of a particular company in such a way that we can say that there is a broader impact to the field as a whole, or a more large scale impact to the region or the industry or the nation as a whole, right? So when we speak of the scale of impact, geographic scope is actually not the focus. After Matter of Dhanasar, we don't necessarily look at whether the impact of your work is hitting every single state in the United States. So geography is not really what we're looking for, but we ask whether the endeavor has national or even global implications within a particular field. And there are some examples that the Matter of Dhanasar gives, which is improved manufacturing processes or medical advances. Because if you think about these things, let's say a new, more efficient treatment for a particular disease is being developed, right? And let's say your endeavor is developing a better solution for a particular disease. This can save millions of lives. and can really, advance the way that this particular disease is being treated. So medical advances, when we speak of medical advances, the benefit is not just on the particular research institution or hospital that you're working with. Because you're developing a new approach that can be used widely across the field, that is the larger impact, the large scale impact that the government really is looking for. Uh, Another way to meet national importance and substantial merit is to show that your endeavor will have substantial positive economic effects to a region or, at a quite a large scale level. This may have national importance, especially if the place that you're developing your project in is classified as an economically depressed region that needs revitalization. Really, the scale of such an impact is important. Again, we're looking for something that is more than a localized impact. So definitely the important thing to consider is that the benefit of your endeavor, your proposed endeavor, must be expected to go beyond your immediate employer or clients. We really need to prove that there will be a broader impact to the field. Now, substantial merit and national importance are two different concepts, according to Matter of Dhanasar. Substantial merit is the easier standard, but you must achieve both substantial merit and national importance. And national importance is where the government will look at the scale of the expected impact on the field. Definitely a larger scale and broader impact is expected for successful NIW cases. Two little notes to go over before going to the next slide is that job shortage issues in the United States. That's a common misconception, a common approach that may not, prove very effective in the NIW context is that that alone cannot support a strong argument for national importance. And one example of this is pilots, and we saw a lot of consultations with people who had heard that if you're a pilot, you will, automatically qualify for a national interest waiver because the U.S. Currently has a shortage of pilots. That was kind of a myth circulating in the internet for a long time. And unfortunately, this this is just simply an approach that will not work because the government will look at what is your impact to the field, not necessarily on what field that you're working in. And we've been speaking about this for in the previous slides as well. But just because there is a job shortage in the United States in a particular field, and if you're just coming in to work in that field, that alone will not, unfortunately, qualify the case for a national interest waiver. Similarly, several appeal cases point out relevant measures for national importance with respect to the nature of what you're doing. So one example of that is teachers. Although teaching definitely is an important thing that someone can propose to do. Unfortunately, when we speak of national importance, it is the position of the government that the beneficiaries of this teaching tend to be limited to the direct students that interact with the teacher and doesn't go beyond this circle of students who directly receive the teaching. And as such, so for example, AAO cases where a PhD graduate has a proposed endeavor which has both research and teaching aspects. We've seen cases where the government found that the research aspect of this person's proposed endeavor did have national importance because it would, help advance scientific knowledge, and the findings of this research would be cited by, many independent researchers providing help to their own research. Whereas by contrast, the teaching part of this person's endeavor was not held to have national importance because the nature of teaching is such that it would tend to only benefit the immediate students who receive that teaching. So when you are framing your proposed endeavor, definitely it is highly recommended to work with a skilled lawyer who can identify the directions of argumentation that can work best to be persuasive for the national importance requirement. All right, so the second prong of the Matter of Dhanasar test is that the applicant must show that they are well positioned to advance the endeavor. And here, the focus is on the individual themselves. So the government will look at the person's background, including experience and education, The government will also ask whether the person has demonstrated a track record of success or influence in the field already. Patents or intellectual property can be helpful evidence of this particular uh, having a record of impact. If you have developed similar technology in the past, and if you've published this through either a patent or, you've published your research findings through an academic journal article, and if those journal articles have been cited by other researchers in your field, that in itself can be proof that you have made an impact in your field and have advanced your field, even before you are working on your proposed endeavor. Now, another helpful category of evidence is if you can show that you already made progress in your endeavor. If you are an entrepreneur who is in the United States on an E2 visa, for example, and if you've already spent several years developing your business, if you can show evidence of traction for your business project, for example, if you've received, proof of interest from major US institutions, if your services or products have been used by household name brands, household name corporations, those, contracts, copies of contracts can, be powerful proof that there is actual demand for your particular product or service in the United States and can help to show that, successful track record. Contracts and tax returns. Evidence of hiring, Forms W-2, for example, if your business projects have already resulted in significant hiring in the United States, those objective forms of evidence can be very helpful in, proving that you're well positioned to continue to make that substantial economic impact. Now, the last and third prong of the Matter of Dhanasar test is to show that on balance, it would be beneficial to the United States to waive the requirements of a job offer and thus of a labor certification. And you can think of this third prong as a balancing test. If you have received awards in your field, or if you've been judging the work of others or things like that, those types of considerations that would come in for EB1A petition can also be applied here to prove to the government that on balance there would be, more benefit to having you advance your endeavor in the field than, have you be replaced by, another minimal qualified worker in the United States. You can draw on evidence from prong one and two. So from prong one, we can talk about the systemic benefits that your work can have to the United States, which is at a large scale. Those large scale benefits can definitely be emphasized. Prong two factors can also be emphasized. If you possess irreplaceable skills, irreplaceable, specialties and specific know-how and specific track record of success, maybe you can prove that it will be difficult to replace those unique skills with a minimally qualified worker from the United States. Two other points you can use if you're an entrepreneur. You can also make the argument that entrepreneurs are self-employed and often not eligible for green cards under the labor certification requirements, such that the NIW will really be the only way one of the only ways that the entrepreneur could qualify for permanent residency. Similarly, entrepreneurs can use the fact that it would be impractical, and sometimes impossible for them to obtain the green card through the labor certification process to show that on balance it would be beneficial to waive the requirements. Another argument that entrepreneurs could use is that if your business project will produce a high number of job creation in the United States, that can also be a countervailing benefit that would serve the Congress's intent on, promoting the growth of the U.S. job market. So by conclusion, Dhanasar definitely specifically notes that entrepreneurial work can lead to an NIW and states that the planned venture does not need to ultimately succeed as long as the applicant can show that it is plausible that it will succeed and that they are well positioned to advance the endeavor. All right, so now let's talk into a little bit more detail about national importance because it has become rather a linchpin of a successful NIW case, and it can definitely be a difficult concept to wrap your head around if you're first becoming familiar with the NIW requirements. So when we speak of national importance, we need to prove the importance of the individual's specific proposed endeavor, and the focus should not be on the importance of the field or occupation that the individual will be working in. Expert letters can be a very important element in persuasively arguing national importance. And when we speak of expert letters, we're not speaking of formulaic and conclusory expert letters that don't really go into detail about why the applicant's work is important. We really want the experts to focus on the specific plan that the applicant will be um, advancing and describe in enough detail about what is the limitation in the field or for society or for the region as a whole, and talk more specifically about how the person's work specifically can improve that problem or limitation or something that the field or the United States is lacking. And really, the expert letters should go beyond just talking about the importance of a field, but really focus on the impact that is specifically tied to the applicant's own endeavor. And so when we speak of the impact, right, benefits to one specific employer alone will usually not be enough. And the government is looking for proof of a broader impact expected to the field or region or the public at large. And let's talk about this through an example. A person developing a drug for a pharmaceutical company may be able to establish national importance by demonstrating the prospective public health benefits of the drug, instead of solely projecting the profits that will accrue to the employer. Similarly, if you can prove that there would be a widespread interest in adapting or licensing a technology, a novel or important manufacturing process that can be used to improve manufacturing practices across that industry, or how the technology stands to impact the development of similar technology by other companies, by becoming a role model. For example, Samsung came out with this uh, foldable phone, and now Apple is going to have a foldable phone, and they're going to, develop a similar technology for that. So those kinds of, endeavors at the cutting edge of a particular industry, really pushing the envelope of a particularly important field of technology, can definitely be one way you can establish a broader impact. Substantial economic benefit and creation of U.S. jobs at a level that is significant with respect to a population or the economy of a region can be another way that you can provide national importance. However, keep in mind that the scale of such benefit must be significant, and you must have enough evidence to show why that would be the case.
Perfect. Thank you, GA. So, we're really going to build off of what GA has already shared. And first of all, talk about what is included in a national interest waiver petition. As GA already mentioned, you need at the start you need to meet certain threshold requirements. So whether that is through having an advanced degree or meeting 3 of the 7 criteria to show exceptional ability, that is step one, is meeting that threshold requirement. So what would be included in the application would be proof that you meet that requirement. So that would be a copy, for example, of your degree if you're qualifying that way. Or if you're qualifying based on experience, as GA mentioned, we're talking letters from past employers talking about how your experience is progressive, the amount of time you worked at a given employer, what your job duties there were, and additional letters from employers talking about how the work progressed over time. If you're meeting 3 of the 7 criteria, the evidence you'll need really comes down to which of the 3 criteria you're trying to meet. Of course, we always try to meet as many of the 7 criteria as possible, because what USCIS will typically do is come back and say, we think you meet one of the criteria, but not the other 2. So you want to try to hit as many as you can, assuming that they are going to exclude at least one of the criteria you're aiming for. You have others to fall back on. But you would think about what are the criteria you're trying to meet? What is the documentation that shows that you meet that criteria? Next is evidence that you qualify for the National Interest Waiver. So the way I like to think about this evidence is really in a few buckets. The first bucket is focused on the endeavor itself. So what GA was talking about, what is it that once you get the national interest waiver, the green card, what is it that you're going to be pursuing in the U.S.? Is that certain research? Is that a business? Whatever that is the endeavor. And bucket one is really talking about why the endeavor itself is of substantial merit, national importance. So you're focusing on highlighting that endeavor. That could be through newspaper articles. It could be through funding that the endeavor has received, for example, through venture capital firms, from national grants. So, for example, if you're focusing on cutting edge research and your research has been funded by the U.S. Department of Energy, that is a wonderful piece of evidence to show that the endeavor itself is actually meeting these criteria of substantial merit and national importance. I'll quickly turn to the next bucket, which is, instead of focusing on the endeavor, is focusing on you, why you are the ideal person to really pursue this endeavor. All right, and the final bucket, which is it kind of automatically follows from the other two, is evidence showing why you should be exempt from the labor certification process, which we typically don't include additional evidence for that piece, because if you're able to show that the endeavor meets the requirements, substantial merit, national importance, and that you meet the requirements as the ideal person to pursue that endeavor, then the labor certification piece typically follows naturally from that. So now, having provided these really two buckets about the endeavor and about you as the applicant, let's look at the evidence. So I mentioned news articles. These are going to be really common for both the endeavor and for you. It's just important to make sure that the evidence actually addresses both the endeavor and you. A given piece of evidence doesn't need to address both. You could have a newspaper article that's about you, and you could have a grant that is specific to your endeavor. You just want to make sure that you do have evidence that addresses both pieces about the endeavor and about you. So let's look at these examples. If there are academic papers, for example, that you've published, if there's any publications, whether that is, I mentioned newspaper articles before, it could be news, could be radio, you really are thinking broadly about anything that might exist that does show that the endeavor meets the requirements and that you as the applicant meet the requirements. And one thing I will say is that we as the lawyers are not going to be necessarily familiar with what is out there about you and your proposed endeavor. So we as attorneys, obviously we are experts in immigration law, but we don't necessarily know your field. To continue with our example, if your field is research in a cutting edge area, say of energy, to continue with that example, we are not experts in energy. We do not know what the cutting edge research is saying. We don't know what the most prestigious prizes are in your field if you're working in energy, for example. So we do look to the client to let us know what they have received, what publications have been put out there about them, about what they're working on, what grants they've received, and why those grants are prestigious. So this really is an opportunity for you to think very broadly about any recognition you've received, any support you've received, whether you individually or your endeavor, that you believe shows someone who's completely unfamiliar with what you plan to do, that what you're working on is of substantial merit and national importance. So do think broadly about that. All right, let's get back to our list. So when we're talking about the applicant as an individual, of course, their resume is important. The degrees they have may very well be important. Any awards they've received as individuals. Expert letters. I do want to focus on this, and I know GA talked about this quite a bit. But the way to think about expert letters, GA said they should not be conclusory. So what that means is a letter from an expert. It doesn't matter who the expert is. A letter from the expert, even the most prestigious person, that says, I'm writing this letter on behalf of John Doe, who qualifies for a national interest waiver. Please give that to them, is going to have no weight because it's not, that is conclusory. It's reaching the conclusion that you should just get the green card. What USCIS is going to look for instead is information that they can use for them to make the decision that you deserve a national interest waiver and should be granted one. So it would be things like, this person has done A, B, and C. That is important because no one else has ever done A, B, and C. And they've changed our field by doing X, Y, and Z. This is how what they've done has been implemented. This is how they've really shaped the field. So things like that, where it really is fact-based, so that the officer can look at that and use those facts. Oh, they received that award. Oh, they received that grant. Oh, they changed the field by doing this. That does seem like something that is of national importance and substantial merit. The other thing that's really important to know about expert letters is that they should build upon primary evidence that's included in the application. So if, for example, the expert letter is saying the applicant has done research that's changed our field, don't leave it at that. Also include the research. Include a copy of the article so that the officer can actually read what the research was. And then the expert letter can contextualize that article because, frankly, a USCIS officer, just like your attorney, is not going to be an expert in energy policy or research. So when they read the academic article that you publish, they're probably not going to understand it very well. But then they're going to have an expert letter that explains to them, this is why that article is significant. That article actually transformed the field, for example. That article actually was implemented and reduced energy costs by 20%. So you want expert letters to add context, to build on primary evidence that you include in the application, and to not be conclusory letters. So we could spend a lot more time on this and exactly what evidence you can use. Think broadly, don't be humble. Really think about anything that would highlight to someone unfamiliar with you or your field why you really are one of the leaders in your field and deserve this green card. The last thing I'll say on this slide is about entrepreneurs. We do have a second slide that will come later that talks about evidence that's specific to entrepreneurs. I will just quickly say that, as GA mentioned, entrepreneurs certainly can qualify for a national interest waiver. They can qualify based on the business endeavor alone. There are certain strategies, though, to strengthen those applications, which we'll get to in a later slide. All right, some recent trends and strategies. So national interest waivers have seen a significant increase recently in the number of applications filed. Probably related to this is the fact that requests for evidence, or RFEs, and denial rates have also increased. Our sense of this is that USCIS is being more difficult, more challenging when it comes to national interest waiver applications. So that is a fact. It is probably more difficult today to have a national interest waiver approved than it was, say, a year and a half ago. That being said, we are seeing plenty of approvals. These are certainly viable petitions if prepared the right way. Past performance doesn't predict or guarantee future outcomes, but it's important to know this is still a viable pathway. So the national interest waiver continues to be a great option for entrepreneurs and people who qualify, even if they are slightly more challenging. Now, third point here, the government has issued policy guidance that clarified several national interest waiver aspects. And this may change given the change in administration, meaning the Trump administration. One thing in particular is that the Trump administration basically, let me back up. The Biden administration issued certain guidance from the White House and the executive branch talking about how certain initiatives, specifically STEM initiatives, science, technology, engineering, and math, so for example, AI, medicine, how these are of particular national importance. So in an NIW application in a STEM field, we would absolutely include, in the past, we would include the White House, publication on the importance of these STEM fields and say the White House itself has said that these fields are of substantial merit and national importance. We unfortunately don't have necessarily the same publications coming out of the White House now. That being said, we would still make similar arguments. Just because the White House has said, this policy memo is rescinded, does not mean we wouldn't make arguments about why science and medicine, technology, engineering, etc., are still important. So, it's yes, it is concerning that the White House has kind of walked back some of that policy, but does not by any means mean that we cannot make similar arguments, and certainly does not mean that these applications are not still approved. We are still seeing them being approved. Now, let's talk about entrepreneur-specific strategies, which I mentioned briefly in the previous slide. So, again, the Matter of Dhanasar was particularly beneficial for two main reasons. The first is that it framed national interest waiver applications in a very helpful way. And we've talked about that, how substantial merit, national importance, endeavor, applicant, that really is the framework provided by the Matter of Dhanasar case. But the second thing that case did is it explicitly acknowledged that entrepreneurs can qualify for a national interest waiver. And that is of course wonderful news. Now, the next question that typically follows from that is, well, okay, great. So I have an E2 business right now that has 3 employees full time, and so I'm ready to apply for a national interest waiver, right? And the answer is unfortunately no. The bar for a national interest waiver for entrepreneurs is higher than, say, for an E2 visa. For a national interest waiver, if you are applying as an entrepreneur based on your business, ideally you would not be relying solely on employment. If you are relying on employment, what I mean by that is job opportunities that your business creates. You need to be creating a significant number of job opportunities, and I'm talking in the dozens, ideally 80, 90, 100 plus jobs that the business is creating. You would probably need a good business plan talking about how you're going to continue to employ those people, ideally increase the number of jobs. You probably would need to emphasize in the application, again, getting to the national importance piece, how you are creating jobs in, say, a socioeconomically distressed area, an area that really will benefit from job creation and economic opportunity in particular. And so again, that is if you're focusing on jobs alone. What we tend to try to do when someone comes to us as an entrepreneur wanting to apply for a national interest waiver is not solely to rely on that job creation piece for the reasons I said before. It is hard to prove to the government that your endeavor is of substantial merit and national importance if you are only creating jobs. Yes, creating jobs is important, but oftentimes USCIS will not see it as important enough to meet the national importance prong. So what can you do to strengthen that? Well, you can think about other ways that your business is actually creating value. To give an example that I like to share, we were approached by an entrepreneur who had created over 100 jobs, but in addition to making that argument that he met the NIW requirement based on that, we looked at how his business is operating and exactly what value it is creating. In his case, He was creating businesses in downtown areas of towns that were really run down over the last decades. They had seen people leave these areas, so there were many buildings that were abandoned, which increased crime rates. And so he would bring in businesses into these areas, revitalizing entire parts of these downtown areas. And we looked at that and we brought in research about how downtown revitalization is actually a very important part of reducing crime and increasing economic activity, having ripple effects that are much broader than just creating jobs for the direct employees. We got an expert letter from an economics professor who was able to substantiate what we were saying. The economics professor was able to talk about how these types of businesses are critical. So that gave our client two bases to say that my endeavor is of substantial merit and national importance. I'm creating jobs, but I am also revitalizing downtown areas and kind of maintaining the culture and heritage of these downtown areas as well. So hopefully that's helpful to think about how entrepreneurs can think about pursuing a national interest waiver. I'm not going to say too much more on what you see on your screen. Really, what you have there are specific examples of evidence that entrepreneurs can use. Really, this comes down to, again, thinking about if you met someone who was completely unfamiliar with your business and you're trying to convince them that my business has substantial merit and national importance, what would you show them? You'd probably show them your tax returns, how well the business is doing, your W-2 forms, how many people you're employing. If you've received venture capital funding, wonderful evidence that other people, other entities have bought into your idea, and you as someone who's pursuing this idea. So things like that are what you want to think about. And of course, expert letters can still play a very important role. For a business, you may be able to get a letter from the mayor of your town talking about how important your business is. Local congressperson, state congressperson, maybe a House of Representatives, even a senator who's talking about how important your endeavor is for their state. These are all things that can really transform an NIW application from, a risky application to one that actually is quite strong. So let's talk about timing and other considerations here. And I'll preface this by saying I'm going to touch on kind of broad ideas and concepts regarding timing. If you do have questions about your specific circumstances, this is an area where a consultation can really help, especially if you're already in the U.S. on a visa and you're looking to pursue a national interest waiver. And we'll talk about why that is in a moment. So, in terms of timing, fortunately, actually, let me take a step back. There's really two parts to a national interest waiver application. The first is an I-140. An I-140 is the name of a form that goes to USCIS, and it basically presents to USCIS the arguments you have for why you are eligible for a green card. And you will include all of the proof we talked about before, national importance, substantial merit, etc. And USCIS, if they approve the I-140, that means that you can then pursue the second part of the application, which is actually applying for the green card or an immigrant visa. So for that first part, the I-140, the only way to apply for an I-140 is to submit an I-140 to USCIS. For the second part, to apply for the immigrant visa or the green card, there are two ways you can do that. You can either apply from within the U.S., it's called an adjustment of status, by filing a form I-485 with USCIS, and that's, again, if you're already here in the U.S. The other way is to file a DS-260 with a consulate abroad, and so you will actually go to the consulate, get your immigrant visa, and then enter the U.S., and when you enter, you will then be issued your green card. So those are the two ways, whether you're inside the U.S. or outside the U.S., to apply for the green card. For the first part, the I-140, USCIS does offer premium processing. Now, premium processing costs about $3,000. Um, but they do guarantee you a decision in 45 business days. So that significantly does reduce the amount of time for the I-140. I think if you don't opt for premium processing, you're probably looking at least 6 months or so for the application to be decided. Frankly, I haven't checked recently. You can Google USCIS processing times and search for the I-140, and you'll see how long they estimate it will take. Uh, but in summary, 45 days is far shorter than it would be if you didn't opt for that service. Now, that does not mean you will necessarily get your green card faster. It means that your I-140 will be approved faster. Whether you get your green card immediately in a few months or several years down the road depends on the visa bulletin. And the visa bulletin is a monthly publication that shows basically how long the lines are for a given green card category. And so for the National Interest Waiver, we're talking about the second employment-based preference category, EB2. So you would look at the visa bulletin, look at your country of birth, and see if there is a wait for that green card. And you would have to wait for your priority date, which is the date you apply, submitted your application, to be current before you can apply for that green card. I know that is complicated. I know I'm going fast. Do schedule a consultation if you want to talk about that further. Right now, Jiyae, do you happen to know if, in general, if there is much of a wait? I think they are backlogged, if I'm not mistaken.
You mean the priority date
Yeah,
backlog for
for
the
EB2.
EB2? Yeah, I would say around 1.5
Yeah,
years.
that's right.
Yeah.
That's right. So right now, for most countries other than China, India, Mexico, Philippines, we're looking at April 2024. So we are seeing, right, exactly as GA said, about a year and a half between filing, basically between filing the I-140 and being
Yeah.
able to apply for the green card. So, okay, now let's get to the next bullet, which is underlying visa status. This is really critical, especially in the current administration. Um, if you are in the United States on another visa, so let's say that you're here on an E2 and you've started your business and it's going very well, you've created dozens of jobs, and you decide to apply for a national interest waiver. Step one is filing the I-140. You need to maintain your underlying E2 while the I-140 is pending. The I-140 does not give you status. Once you file, let's say your I-140 is approved, and you filed your I-485, there it gets a little bit nuanced. It is still a best practice to maintain your E2 until your I-485 is decided and you have a green card in hand. In the past, that wasn't as much an issue, but under the current administration, there is a anecdotal evidence that the government is actually creating issues for people who do not maintain their underlying status even while the I-485 is pending. Now, one of the tricky things here is that an E2 visa and many of the other temporary visas, like the TN, the E1, they are not dual intent. What that means is if you have one of those visas, you need to plan to leave the country. A green card, a national interest waiver, in contrast, by definition, is permanent. So if you are in the U.S. on a temporary visa, like an E2, how do you at the same time tell the government, well, I plan to leave the country on my E2 after the E2 ends, but I also want a green card? That is where you get into some thorny landscape that we would be happy to help you navigate, but the takeaway is that you cannot use a temporary visa to enter the U.S. if your intention is to adjust your status when you enter the U.S. However, if you're entering the U.S. on an E2 and you plan to process your immigrant visa at a consulate, that is generally fine. Because you're not planning to stay in the U.S. on your E2. You're planning to leave, get your immigrant visa, and come back in. You also do want to make sure in general that your underlying status, whether it's E2, TN, whatever it is, that you have a good amount of time on it before you file your I-140. again, so that you can maintain that underlying status while the national interest waiver is pending. All right. Pros and cons of adjusting status in the U.S. versus consular processing. Really, this comes down to your specific circumstances. Consular processing is great because it reduces the risk that you will have issues if you have a temporary visa and you're going to be entering and exiting the U.S. while your national interest waiver is pending. So by choosing consular processing, which frankly tends to be what we recommend, you can generally use your underlying visa, whether that's an F1 student visa, an E2 visa, whatever it is. You would be able to say, I'm going to a consulate for my immigrant visa application. Adjusting status can be a good option for people if the circumstances are right. Again, if they're already here, if they don't need to travel, because you do need to wait between filing the I-485 and getting your travel permit. Once you file your I-485, you can file at the same time for a work permit and a travel permit. If you leave before that travel permit is issued, you abandon the application. So you do need to wait for that travel permit. That can take 6 months, 9 months, somewhere around there. So you do need to be able to stay in the U.S. So if you have family abroad that you need to visit, then adjusting status can be tricky. So anyway, that is a topic that is better suited over a consultation, though, if you do have questions. So please do schedule that. Unless we have a case study, I'm not going to get into much detail on this, but it is helpful to look at just to see how a national interest waiver plays out and what we mean when we say substantial merit and national importance. So this example is an example we like to share. It's an entrepreneur that started a small consulting firm that provided services to U.S. veterans. So this basically, the thrust of this application was to highlight that this is a real issue. Veterans come back from conflict zones with real challenges, and it is well documented that the government and the private sector and the NGO space, none of them completely meet this challenge. So he started this organization to help to bridge this gap between the need for these services and the supply of them. That is a wonderful way to frame substantial merit and national importance. You're talking veterans, you're talking mental health issues, you're talking a significant number of people. So that is the endeavor. Why is he the best person, the person who is well positioned to advance the proposed endeavor? Well, he was able to include letters from government officials, business and philanthropic leaders about the success he has had doing this. He was able to include newspaper articles, other publications where objective news sources had talked about his ability to do this and his success doing this. And again, this tends to flow automatically. This third prong, showing the government why he should not have to go through the labor certification process, that flowed naturally from the first two. Well, he's not applying for a job. There's really nobody competing for this job. If someone is competing for this job, well, they should start their own company. There's nothing stopping them from doing that. And there's a need here, and it's an underserved need. So that makes it clear. This is an entrepreneur who is not really competing with the domestic labor market. In fact, he's creating jobs for the domestic labor market, and therefore the labor certification process should be waived. So again, a helpful example to just kind of provide, really in practice what it means by substantial merit, national importance, being well positioned to advance the proposed endeavor, what evidence you can include in that, and how that naturally leads to meeting that third prong regarding labor certification. So it is now 11 o'clock. We really do appreciate you taking the time to join us today. Do keep an eye out for our follow-up email. We hope to see you on future webinars. And Jiyae, thank you for taking the time.
Thank you, Dustin.
Have a great day.